Welcome back to Hello Nigeria. It's time for our top story. Today we're looking at a very important but oftentimes neglected topic, wills and administration of estates. We'll be looking at some legal terms. What does it mean for someone to die testate, intestate? We'll be looking at all this and breaking it down to you in terms that you will understand. And to help us do this, we have the person of Barrister Ezeala Chukwuma. Thank you so much for joining us, sir.
Thanks for joining us on Hello Nigeria.
Thank you. Good to have you. So let's talk about the first basic thing. There are certain terms we'd like for you to break. When we hear about wills and administration of estates, there are certain terms like when someone dies testate, when someone dies intestate. What does that mean?
First is to say, what is a will?
Yes.
A will simply means somebody speaking from the grave. That is, the person is dead, but he is talking, he is communicating to you. He is giving you information of what he wants from the grave, instructions of what he wants from the grave.
But he writes it when he's alive.
Yes, he wrote it when he was alive, you know, but it doesn't take effect at the time he wrote it. It can only take effect. That means it's in the active, you know, so to say. It will be in the active voice only when he's dead. That it means he's speaking directly at that time.
Okay. So
that is the simple meaning of it.
So
now,
the testate, intestate, beneficiaries.
Yes. Now, when there is a will, it means the person died testate. He becomes a testator. Now, when there is no will, it means the person dies intestate. That means he didn't speak, or he is not speaking from the grave. And the beneficiaries of a will are people who are directly benefiting from the will. The people who are going to take his properties or who will take the instructions, money, anything. So the way he has spoken. So it's like, putting it in a layman's language, it's like a man sitting saying, you are taking this, you are taking that, you are taking the other one. So his speaking is on the active, is in the active voice.
So what are the legal complications of unwilled properties?
Yes.
What are some of the matters that can arise as a result of this?
Yes, first is, you know, if you talk, we may be going into advantages and disadvantages of a will. First is the taxes over a will. You know, if one dies intestate, the taxes to pay will be higher. That is one. At the probate, before letters of administration will be given to whoever it's going to be given to. That's one. Two is, it means that very likely that the intentions of the dead person will not be actualized, assuming there is no, that is when there is no will. But when there is will, it means what the person really wanted will be achieved. That for payments, or rather for money to be spent, take for instance, you pay 15% if the person dies intestate, but 10% if the person dies testate. Now, but it goes beyond the money or taxes that will be paid. It also goes into the wishes of the man has been done, the problems that may arise in the family over struggle over the property will not be there. The man would have appointed, like when you look at will, because in a will you will have to also appoint who will administer over these properties, who is going to make sure it is shared properly. The man would have known some of his friends who he can trust.
The administrator doesn't have to be a family member. Or
It doesn't. No. That is where there is. A man, before he leaves, may decide who will share the property. It can be somebody else. But when the man is dead, intestate, the only people who can now apply for it becomes family members.
And now, at this point, what are they called? We know that when the man decides who would share his property, there's what they're called. But if he dies intestate, and the court has to do that for him, I think there's the executive.
Yeah, yes. Well, now, when a man dies, people apply for probate. When they apply for probate, you now apply for letters of administration, those who are going to be executors of the property. The executors of the property will apply. If the man died intestate, the executors of the property will apply for letters of administration to become executors of the property. Now, if the man had died, if the man died as a testator, that is testate, the man will have appointed what you call personal representatives. Those personal representatives will immediately start administering the properties and then apply for official recognition that they are doing it. So the effect is, if there is a will, immediately the man drops, the person surfaces and starts administering the estate immediately while applying for letter of administration. But if the man dies intestate, nobody can administer the property legally. So somebody will have to apply. Whenever it's granted, that's when the person will start.
At what age or at what point in someone's life should you begin to think of writing a will? Because we come from a very superstitious culture that when you think something or when you talk about will, it's like you're wishing death upon yourself. So people don't want to touch it. It's a very dicey issue. And there's some people that really don't have much property apart from shoes and radio and television. So is it for everyone?
Yeah, no, it depends on the person. Actually, when one is 18, one should be able to write a will.
Wow.
You know, except you don't care about what people after you. You know, there are some people that says, whatever the living wants to do, let them do. They want to kill themselves, let them kill themselves. It's not your concern. Otherwise, shoes can be contested for, watches can be contested for. Even if you have 20,000 naira in there, can be contested. And people can really die because of that. You know, so that is why it's important to say, this is what you are going to do. This is how I want these things to be taken care of. So it solves the problems.
Okay, now, we know that the Wills Act makes for provisions on how a will should be written and the process. Can you take us through it?
Yes, it's a technical process, very technical process. That is why to ask somebody to write a will for you, there are two things you must consider. One, whether the person is competent and can write it well. Two, is also the trust aspect of it. So you must be able to have real confidence in the person.
And
now,
confidentiality too.
And confidentiality of the person. You know, there are cases of people who will write a will, either keep it careful, because apart from confidentiality, to what extent can you keep documents? If you write a will and maybe you're related, not related, maybe you have a very good rapport with the family, and you keep it somewhere where another person can go and then have a look on it, it can cause problems. The whole family will hear it. So apart from confidentiality aspect, also what type of person are you? A person that can keep documents well, you know, to avoid problems. But that does not mean that the beneficiaries, that it is a taboo for the beneficiaries to see. No, it's not a taboo, because the person can actually make the beneficiaries know what he has distributed. That's not a problem. But for certain reasons, the testator may not want the beneficiaries to know the contents of the will. And besides, somebody who is not favored by the will can decide to steal the will. And if the will is stolen, it becomes a problem when the man dies.
Okay, so now the procedures and processes, when the man decides he wants to write a will, he should invite his lawyer?
He should invite his lawyer, not his lawyer who has good information on how to write a will. Now, to write a will, you will need, apart from getting the necessary information from the man, technical information from the man, you will need the property. Because if, for instance, you say, I will my property at number 10, Okodowa, or rather, I will my property at Okodowa Street. Sometimes, if you don't have specification, the will fail. Two, if there is problem of contesting the will and you did not specify things the way it will be, or the person you are going to give is also a problem. If you do not have the necessary witnesses to a will, because in a will, one thing that must be important is the witnesses. At what time did they sign? Did they sign in the presence of the testator? If somebody doesn't know how to write a will, decides to say, oh, I've written his will, he calls Mr. Okechukwu, and the lawyer maybe takes the will to Mr. Okechukwu to sign, it has voided the will.
So that means the two witnesses must be present at the same time?
The two witnesses must sign before the testator. They must sign before the key point is that the testator must witness them, sign. And they themselves will normally have seen testator sign, or I say this is what I've signed.
Okay. Interesting.
Yes.
So when we have incidences of, I'm sure there are lots of buildings in Lagos, Beware of My Son, Korede, and things like that. Is it as a fallout of not writing a will?
Yes, most times it's as a fallout of not writing a will. Sometimes it's also as a fallout of people contesting the will, or people not believing that the will was actually written by their father or made by their father. Because And there are also some other issues. If a will is written and, the beneficiaries do not believe that as at the time the man is writing the will, that he has the necessary mental faculty to write. If a man has a mistress and there is undue influence by the mistress or by any other person, a man may be sick and the mistress may say, write the will, write the will. This is what you know, you won't give me this one, you will give me the other one. And the man is looking at somebody who is taking care of him, and he obeys what the woman is saying or what the person is saying.
Okay. So that means it's very important for the testator to have a sound mind at the time that the will is being written and signed.
Yes.
All right. So we'll take a very quick break. When we come back, we'll still be speaking some more about wills. Maybe this time we'll be looking at, the roles of spouses when it comes to benefiting from the will. When we come back, our barrister will still be here with us in the studio. Welcome back to Hello Nigeria. We're still looking at wills and administration of estates. We're speaking with Barrister Ezeala Chukwuma, and he's been explaining to us what a will is, why you need a will, a brief reiteration of some of the things we've spoken about, and some key terms. When a person dies testate, that means the person died writing a will. When a person dies intestate, the person dies without having written a will. And a will speaks up from the death of a person. It only starts to take effect after the person has died. This is some of the key things we've looked at before we went on the break. Now, I was going to ask you before we went on the break, what are the roles of spouses when it comes to benefiting from a will? Can a spouse benefit from a will on the one hand? And on the second hand, when a person gets married, do you think at that point they should adjust their will to include their spouses?
A will can be changed at any time. It can be changed 50 times before the person dies. As situation changes for him, as he thinks it, as he deems it necessary, he will change his will. Now, any person can benefit from a will. An outsider, a church, an animal, anybody can benefit from a will. It depends on the person, because the person wants to give his properties or his wealth to whoever he loved or he loves. So this is about, and you cannot query how he wants to give. Just some people may say, I am your first son, you must give me a lion's share. No. The person may decide to give the last son the whole thing. It's not your business.
That is not contest. You can't contest.
You can only...
If there are no technical...
Yes, if there's no technical... If you say, yes, this man did it, and he did it with his full mind, there's nothing you're contesting again.
What if dependents or children or the wife of the man feels, my husband should have left me something, he left me nothing? Is there any provision that would enable them to at least challenge the man's will?
At least have some fairness in it.
On that ground, he cannot challenge it that he should have. As long as the woman or the child or the children says he was of sound mind, there was no undue influence, the will was written well, there's nothing, there is nothing anybody can do about it.
What method does the government use to administer in the case of interstate persons?
Now, that is where there is an issue. In the case of intestate person, now, the family, certainly the spouse and the children usually will apply for letter of administration. They apply to probate for letter of administration. Now, the properties are usually shared among the wife, the children, the parents of the person if still alive, and the dependents of the person. Dependence means if a man is taking care of his brother,
extended family.
It can be extended family. If a man is taking, particularly of the same blood, if a man, for instance, is taking care of his brother who is 15, and there will be provision for that person. If the man is taking care of the stepmother, for instance, there will be provision for that person. As long as there is this proof that this man was taking care of this. So these are, but the people that will apply for the will be the spouse, the children. But as they are sharing, those people will say, yes, we're interested in this man. This is what he was doing.
Okay. Now, what happens where a man or a woman fails to properly dispose of all their properties through the will? So, for example, they wrote their will in 2015, whereas in 2016 they bought a house, a car. They had not yet amended their will to include these new additions, and then the person dies. So what happens to the other part of the property that has not yet been allocated via the will?
Now, if there is a property that was not allocated, the property is just like, if there is property that was not allocated, it fails because it's not part of the will. It's just like if one gives a property to somebody. A will disposal of property by a will, a particular property can fail. For instance, if a man decides to, will speak, like we said, will speaks
After.
after the death. Now, if something is given to Mr. Kolade, for instance, who is his friend, but who is not a member of the family, and Mr. Kolade dies before the man dies, that property cannot go to Mr. Kolade. It stays hanging, becomes subject of sale or subject of further procedures. And what happens to those properties that fails in terms of giving over to the... What simply happens? Normally, the man in the testament will say all other properties will go to this person. He will say how the other things that he did not mention will have to be disposed most times.
Okay.
But where it doesn't, where the man did not provide for it, the executors can now decide to do it the way they think is fair. It's just like those properties are we usually within the area where you say those properties are a kind of intestate. If a man dies intestate, things will still be done. The only thing is that it will now be the people he appointed that will administer those properties and share it the way it should be.
Okay.
All right, then also let's look at children. When a person wants to give out gifts to his children, but these children are minors, is there any procedure or process to go with that?
Yeah, children, when they are less than 18, they cannot hold property. They cannot legally own property. They cannot hold property. So what the man ordinarily would do is to what you call trust. Either the administrators, because the administrators or the personal representatives will also be trustees. They will hold it for the children until the children are of age. Or the man may decide to appoint somebody else as trustees of the will. And those people, the property will remain with those persons. Take, for instance, if a man has a child outside wedlock, and there are children or a child there, the man may decide to say, I give my property, I give number 10 Oyimbo Street to my son, Jide. But the mother, so and so, to hold the property in trust for him.
So when he doesn't put anybody to hold the property in trust?
The property fails because the person cannot hold the property at the time. These are technicalities in the will. Because the person doesn't have capacity to hold property at the time of death, except the person has reached 18 at the time of death. That's the only time. But
so there are so many technicalities involved. I think it's safe to say it's important for one to just have a lawyer when it comes to preparing one's will to avoid any of these technicalities that can make the issue fail, the will fail.
Yes.
I think another important part we need to look at are those who are allowed to attest to the will.
Yes.
Can the person's spouse, so those who are attesting to the will are those who are signing in presence of the person making the will. Can a person's spouse attest to the will? Are there any exceptions? Are there any category of people that are allowed to sign to the will? Or are there any people that are totally unallowed by law to attest to the will?
Generally, beneficiaries are not allowed to attest to the will. Beneficiaries.
So anybody who is benefiting from the will cannot?
Yes. Just like even the lawyer. If the lawyer's payment is dependent on the will and he signs it, his benefit from there will fail. So
it's about fairness.
Yes, it's about fairness. Because if the person signs, tomorrow the person can go, if for instance 3 persons that benefit signs, they can tomorrow go and do anything and still sign and go. So it's just to be sure things, these are strict rules. And another thing we may need to look at is, when I say that gifts can fail, if the person is not, if the person dies, if the person predeceases, we say when the beneficiary predeceases the testator, the gift will fail. But if the beneficiary is a child of the testator, the gift will not fail. If the beneficiary has a child, the gift will go to the child.
So if I
but
get
if
you
it's
correctly,
another person, yes.
If I get you correctly, so Mr. Tola wrote a will, and he says that they should give his property or his car, a particular car, to Mr. Boyega when he dies.
Yes.
Or however, Mr. Boyega now dies before Mr. Tola.
Yes.
The will should fail normally.
Yes.
But if Mr. Boyega has a little child, or maybe not a baby, but has a child,
yes.
so the car automatically goes to his child.
As long as Mr. Boyega is his child, is the testator's child.
Okay, okay.
As long as it's the testator's child. If it's not the testator's child, the gift will fail.
Now let's look at the institution of marriage and spouses. They often say two become one, and people shouldn't keep secrets from each other. So, but you've said that if you write a will, you shouldn't. The beneficiaries shouldn't know the content of the will. And is that not keeping secrets away from your partner?
No, they should not attest, I think.
No. What I said is that many testators will not want, it does not invalidate a will that the testator, rather that the beneficiary knows the content of the will. It doesn't, in itself,
but
invalidate
they
a will.
Attest.
But they cannot attest to the will.
That's clear.
Yes, that's just it. So it's not a question of whether you want your wife to know about the will or not.
All right. Thank you so much for this very extensive lecture on wills and administrations. We'll be speaking with Barrister Ezeala Chukwuma. He's a legal practitioner and senior partner at Chancellor Partners. He's also a notary public, a chartered arbitrator, and a mediator. He has been in active practice for more than 17 years. He advises on commercial activities, estates, and wills, and he has consulted for various international and local agencies in Nigeria and beyond, including collaborations with DFI, Ministerial, USAID, and US Consulate, etc. You can see why he's very, very vast in this area because it is his area of expertise. So thank you very much. Before we let you go, have you written your will?
We want to put him on the spot.
So have you written your will?
I may not want to answer.
Oh, you plead the fifth. All right. So we are advising you and urging you, if you have properties, it doesn't mean we're thinking you're going to die the next minute. We're just urging you that to prevent trouble after your death, you can actually decide how you want things to be. It might sound like a morbid or tasteless joke, but the truth is the drama that comes up after one's death is rather preventable, by one preparing a will to avoid all that. Thank you so much for joining us. We're going on a very quick break. When we return, we'll be wrapping things up slowly. If it's your birthday, you get to find out who your birthday mates are after this break.
To enjoy more of these our Ogbonge videos when you just watch, press this button to subscribe on top of our YouTube page. You go love am.